I have been given this onerous task of conducting today's proceedings, and I am happy to perform this duty and contribute my bit in today's conclave. First of all, may I request all the participants present here to put their mobile phone on this silent mode so that we can really enjoy and do not disturb our colleagues or the speakers. Now, may I request Mr. K.C. Mittal, Secretary, AICC Legal Cell, RTI and Human Rights Department, to kindly accompany our esteemed speakers for tonight, today's evening, Mr. P. Chidamabaram, Mr. Vivek Tankha, and Mr. Yashovardhan Azad and Mr. Narendra Hooda on this stage so that we can commence these proceedings. Kindly. I welcome all of you on the stage. Thank you. Please. It's a bit struggle because the chairs are a bit congested. Please. Let's begin the program formally. I request Mr. K.C. Mittal, Secretary, AICC Legal Department, to give his welcome address and commence this program. Mr. K.C. Mittal, hand over to you.
Honorable members of the Parliament, office bearers and members of the Bar Associations, senior advocates, distinguished guests, esteemed colleagues, and my dear friends. It is my distinct honor and a privilege to welcome you to this conclave of three criminal laws. Today we gathered not just as professionals, but as custodians of justice, champions of the rule of law, and advocates for the fundamental rights and freedom that forms the bedrock of our society. Apart from seasoned politicians, senior lawmakers, our gathering today brings together some of the finest judicial minds, dedicated practitioners, and passionate activists. This conclave represents a unique opportunity to engage in meaningful dialogue, share our thoughts, and chalk out future course of action to deal with the pressing legal challenges put forward by these three laws. We stand at the pivotal moment in history, where the law has to evolve not only to meet the complexities of a rapidly changing world, but also to meet the aspirations of the common citizens. Issues such as human dignity, liberty, privacy, constitutional legal rights of the people require our immediate attention and thoughtful deliberations, particularly in view of some of the provisions of the three criminal laws brought by the government without any deliberations with the stakeholders. It is through forums like this that we can collectively forge the path forward to deal with these challenges. Over the next few hours, we'll be privileged to hear from stellar lineup of speakers who will share their insights and expertise on these laws. I encourage all of you to actively participate, which will help shape the future of our legal system. I would like to extend my heartiest gratitude to Shri P. Chidambaram ji, who is the driving force behind this program and all the speakers for their invaluable contribution. Your willingness to share your knowledge and experiences what makes this conclave truly exceptional. Additionally, I would like to express my sincere thanks to the organizing committee of their dedication, hard work in bringing this event to fruit. Your support and commitment are greatly appreciated. As we embark on this journey of learning and discovery, let us remember the profound impact that our collective effort can have on the pursuit of justice and equality. May this conclave inspire us to strive for excellence, uphold the highest ethical standards, and work tirelessly to ensure that law serves as a beacon of hope and fairness to all. Once again, I welcome to the conclave, and I would look forward to the enlightening thoughts and deliberations. Thank you very much.
Thank you, Ms. Mittal. We also welcome Mr. Malwinder Singh Kang, Member Parliament, Aam Aadmi Party, amongst us, who has joined us on the stage. He is also one of our speakers for today's conclave. Now, may I request Mr. Vivek Tankha, Senior Advocate, Member Parliament, to share his views with this audience. A short introduction, though he does not need an introduction. I personally take him as my mentor in Supreme Court. I remember when I first contested my election in Supreme Court Bar Association, I went to seek his blessings, and he was kind enough to not only support him, give his wishing, but do everything for me. Thank you very much, Mr. Thank you.
All I can say that the bar has been very kind to all of us. Mr. Chidamabaram, Mr. Kang, Azad Sahab, Huda Sahab, Mittal Sahab, and all the distinguished guests, friends from the bar, ladies and gentlemen, it's not a very difficult topic to speak about, because there's so much to speak. But our time is limited because there's so many speakers. So let me tell you my impressions of the three laws that were passed. One as a lawyer, one second as a parliamentarian, and third as a citizen. I used to always feel when these laws were being passed in the parliament, with nearly 150 opposition MPs suspended, there was no debate. There was a one-sided debate. Who on earth would like to pass a law which is going to impact 140 crore people on a daily basis without a full debate? 150 MPs were suspended. I think the only three not suspended were Mr. Chidamabaram, myself, and Mr. Sibal. You were not suspended, sir. I'm not wrong. So three lawyers were not suspended, everybody else stood suspended. So the point I'm trying to make is, how do you even think that you can make a law which is going to impact every day, everybody, on a daily basis, and without a debate? Who benefits? Frankly speaking, I don't know who benefits, and what government thinks that by changing the title, you bring revolution. We were used to these. There were three laws. Of course, the government of India had not enacted, except CRPC, Indian Evidence Act, Indian Penal Code. These were 150 years old laws. Lord Macaulay drafted them, I remember. We were taught in law faculty. And each section was so precisely drafted that I remember our professors teaching us what is the meaning of intent, what is the meaning of motive, what is the meaning of knowledge, what is mens rea, what is not mensia, what is mensia amounting to murder, not amounting to murder, what is kidnapping, what is abduction, what is sedition. You know, all this we learned, and with the sections. Very commonly used word was, section was 420. उसमें फिल्म भी बनी, She 420. Raj Kapoor, I think, was the star in that film. So, the moment somebody cheated, you know it's 420. What you get by changing the sections, all numbers all over, they have just, even if they have retained the section, the content, they have changed the number. What are you, I mean, frankly speaking, I can't even fathom what they are trying to achieve. You have put the entire administration in trouble. As lawyers, we are fiddling with pages to find out which section is now the new section. The judges also don't know the section. The police in the police station doesn't know the section. What have you, I'm really trying to fathom what have they gained. Except, आपने word भारतीय लिख दिया. अरे आपको इतना प्रेम था भारतीय लिखने का, तो you could have amended the title. Nobody would have objected. And believe me, if you look at the list of laws and the titles, it's only before independence that you had something like Indian Penal Code or Indian Evidence Act. Post-independence, we didn't have to reiterate India. It was presumed that the Indian Parliament would pass law for India. So it was the Stamp Act. It was the Consumer Protection Act. It was the Registration Act, whichever act you see. So what I'm trying to say is, what did they do? What did they achieve by this cut-paste job? I can go into section by section. No doubt there are some sections which I would have wanted them to introduce by way of amendment in the present law, like community service. Of course, your penology, the concept of penology has to change. We are in a reformative era where you don't have to send people to jail every time for everything. They can be punished with other imaginative punishments, make them work for the victims, make them compensate for the victims. And Supreme Court had already started this system, this in some cases. I know of that also. So what I'm trying to say is that you did make some changes. Now, for instance, I'll just tell you, in IPC, they said they brought in a section which is in my opinion, very dangerous. They said if somebody promises to marry a lady and doesn't fulfill the promise, he will be accused of rape. Now, believe me, I'm not a person who indulges or encourages promiscuous society. But the problem is these sections are going to be misused. What is your experience of the Dowry Act? Aren't the courts granting bail at asking? I remember Justice Bhatt in 1994, when we had challenged the constitutional validity of the Atrocities Act, Section 38, that you can't take away in an absolute way the right of somebody who may be innocent to seek anticipatory bail. Bail was denied in that case, if you remember. So, I still recollect that the Supreme Court upset the High Court judgment, restored the provision of 38. They said no, there will be no anticipatory bail. But what has the Supreme Court done today? It has said if you don't make out a case under the Atrocities Act, bail can be granted. So anticipatory bail was for such cases where no case is made out. You don't give anticipatory bail where the case is made out, obviously not. So what I am trying to say again and again is, section after section some sections they have tried to amend, and I was wondering how many sections have they amended in total? I was told 90 to 95% of the sections are the same. It's only 2, 3, 4% sections that have been amended. So for 3%, 4% amendment, you bring a new law, 3 new laws with different sections for each of the contents. So my issue is, you have created a problem for all of us. The whole judicial system, the policing system, the enforcement system, the investigating system would be now in a disarray. I know today the cases in the courts are whether this provision is prospective or this is retrospective. For the next 5, 10 years, you will be fighting these cases. So you're only adding to litigation. And then you have brought in something that 180 days the police can keep you in custody. Imagine in India, you're not safe with police for 5 days, you're talking of 180 days. And why does the police want to keep somebody for 180 days? Police is not, you are not supposed to make a confession to the police. Confession to the police was not accepted by our laws only because they knew that India confessions are extracted. That was the experience of lawmakers and the country. So what have they done? They've also said voluntary confession to a police officer would be permitted. No, I'm telling you, all this is going to lead to huge issues. There will be huge fights on this. So they've not created anything, they've only created trouble for all of us. And good for lawyers. Because I'm sure with all this ambiguities, the lawyers will have a lot of work. But society doesn't get help. Nah. The question is, these laws are for the society. So again, I mean, you look at other provisions also. I mean, they took away sedition, they brought in treason. And then what is an organized crime? Somebody snatches your purse, that's an organized crime. So they've also tried to trivialize the law. So I think for the sake of changing, you bring a change is not a change. Change is when change occurs. And I'm not against a change. Every society is an evolving society. Society evolves. We need new laws also. But that law has to be deeply deliberated and thought over. What happened to the 3 farm bills? None of us could speak. I was wanting to bring an amendment. I was not even allowed because I was in the other house and nobody could see my hand. You rushed that 3 laws. But the farmers of Punjab and Haryana and Rajasthan were sitting there for 1 year. They forced you to withdraw the 3 laws. So do you want the bar to do that also? Do you want the judiciary also to come down heavily, gradually, as they unravel?
Bar did.
Yeah, they're already doing, I'm sure.
Bar did it. Delhi Coordination Committee of...
So all I'm trying to say is, why are you inviting resistance? Who benefits from resistance? And why do you bring resistance in an established system? This is a 150-year-old established system of crime detection, crime trial, investigation, conviction, appeal. You have tried to tamper with it for no reason, which is intelligible. So my submission today is, this is something which came as a surprise, should not have come. It should have been properly deliberated, but by not deliberating and keeping the opposition out of it. You have only invited criticism and chaos, and this chaos will get reflected in the courts very soon, in the investigations, in the police actions, in the detentions, in the custody. So at the end of the day, who's the loser? It is the same Bharat for which title you were fighting for, to bring that optics. It's the Bharat which is going to lose. BJP will not lose, the NDA will not lose. It's the Bharat which will lose. And at the end of the day, we will all be rethinking how to get back to the old situation, like we keep thinking how we'll get back to the old parliament. You know, today my problem let me just, in an aside, let me tell you, today we have Rajya Sabha and Lok Sabha. We have different houses. Once we come out of the house, there is no central hall. So I don't know anybody who's in the Lok Sabha, and the Lok Sabha will not know, members will not know who's in the Rajya Sabha. We are not supposed to meet. If you want, you can go to the cafeteria, have your cup of coffee, or go back to your office. This was not my parliament. So thank you very much, Mr. Mittal, you took the initiative, and I came here also because Mr. Chidamabaram told me that, Vivek, you have to come. And let me tell you, Mr. Chidamabaram is somebody I have always looked up at. He came to my hometown in 79 for the first time. 79, I remember, when I invited him to argue a case. And since then, I've always been close to him. So all I can say is, it's a good way to start your opposition to a wrong act. Thank you. Jai Hind.
Thank you very much, Mr. Vivek Tankha ji. In the meantime, we have Ms. Sushmita Dev, Member Parliament TMC, joining us. I welcome her on the dais. Now, proceeding with the program, may I request our patron, today's program's initiator, and the person who is force behind today's program, Mr. P. Chidamabaram, to deliver his keynote address for today's evening. Mr. P. Chidamabaram, sir.
Mr. K.C. Mittal, Secretary of the AICC's Legal, Human Rights and RTI Department, his colleagues who have taken the initiative to organize this conclave, fellow lawyers, fellow members of Parliament, other distinguished speakers like Mr. Azad. Good afternoon to all of you. Several eminent lawyers and several members of Parliament will address this conclave. And the time allotted to each one is limited because we have to get all the views on board. I intend to follow that time limit and set an example like my friend Vivek Tankha did, just flagging a few points, and I'm sure other speakers will flag more points. Firstly, I have compared in the parliamentary committee, I have compared the old law and the new law section by section. I have made this point before, and nobody in government has been able to repudiate the point. 90 to 95% of the Indian Penal Code has been copied and pasted. 95% of the Criminal Procedure Code has been copied and pasted. 98 to 99% of the Indian Evidence Act has been copied and pasted. The media is here. On behalf of the legal cell, I'm throwing an open challenge to anybody in government who can come and prove that my statement is wrong. If you're copying and pasting between 90 to 99% of the three laws, why copy and paste? Why change the numbers? Why change the title in a language which is indeed one of the official languages, which is indeed one of the national languages, but completely alien to a large part of India? And eventually, criminal laws have to be administered by magistrates' courts. The laws will be translated into Tamil and Telugu and Kannada and Bengali and Odia. Nobody is going to use this name. They will all translate it into the local language, and at the magistrate's court and the sub-court and the district court, it's only the translated text of the act will be used. Be that as it may, I say that this entire exercise was wasteful. The entire exercise, Vivek asked, for what purpose? The only purpose I can see is to confuse everybody. To confuse lawyers, to confuse the police, to confuse the judges. Everybody is thrown into utter confusion. Everybody has to relearn the law. Everybody has to relearn the sections. That is point one. The second point is, some provisions are totally retrograde. Look at the old section on sedition, 124 capital A, and look at the new section. Under the Supreme Court's orders, all sedition cases are kept in abeyance. They cannot be tried today. Yet the new section makes it worse. The new section, please compare it word by word, it makes it worse. So what the Supreme Court of India said, that the sedition provision is antiquated, retrograde, and we therefore stay all proceedings, all trials under sedition has been replaced by a new section which is make it worse. Death penalty has been retained. There are only a few countries which retain the death penalty. Most democratic and civilized countries have abolished death penalty. In India itself, in the last 7 or 8 years, only 6 sentences of death have been confirmed by the Supreme Court. Only 6. Why have the death penalty? You have introduced a new penalty, imprisonment for the remainder of a person's life. That, according to me, is as good as death penalty, without snuffing out life. In fact, it is worse than death penalty, because death penalty puts an end to his agony. But imprisonment for the remainder of one's life means he will regret it for the rest of his life. Having introduced that section, having introduced that provision, why retain death penalty? The subsidiary point is, you have introduced another retrograde punishment, solitary confinement. No civilized country has solitary confinement. Solitary confinement dehumanizes the criminal, the convict. It creates tremendous mental disturbances, and most people sent to solitary confinement lose their sanity. Why are you heaping upon a convict a punishment like he will lose his sanity by sending him to solitary confinement? So I think there are retrograde provisions. I won't detail all of them. I'm sure other speakers will detail the retrograde provisions. The third point, and the most important point I want to make, is the bail provisions. I have analyzed it. I've heard Justice Mukta Gupta analyze it. I've heard Mr. Kapil Sibal analyze it. I've heard Justice Madan Lokur analyze it. We conducted an interview for Kapil's YouTube channel. My view is, I'm willing to be corrected by other eminent lawyers practicing on the criminal side. Today, my conclusion is, nobody can get bail for 60 days to 90 days, whatever the offense is. If it's a cognizable offense, if the police want custody, nobody can get bail for 60 to 90 days. Why do I say so? Earlier, 15 days police custody was available to the police in one stretch. In the first 15 days, you cannot ask for custody in bits and pieces once you get bail. Today, the 15 days can be over in bits and pieces. They will ask for bail, ask for police custody for 3 days, and then the prosecutor will tell the judge, I'm going to come back and ask for police custody. What will the magistrate do? He cannot give him bail, because once he gives him bail, you can't give him police custody. Please look at the peculiar situation. The police ask for custody for 3 days and tell the magistrate, I will come back and ask for more custody. So what is the choice before the magistrate? Can he grant him bail? Because he cannot grant him bail. Once you grant bail, you can't give him police custody again. So he'll have to necessarily send you to judicial custody. And after judicial custody, for 1 week, the police custody for another 3 days, another judicial custody for 15 days, another police custody for 3 days. As long as the police keep 1 or 2 days at the end, the 58th day or the 59th day, and ask it in bits and pieces, the magistrate has no choice but to grant him the custody, send him to judicial custody, send him back to police custody, send him to judicial custody, and then give the 58th and 59th day for police custody and grant him bail on the 60th day. This is a completely retrograde provision. Justice Krishna has said many years ago, bail is the rule, jail is the exception. Chief Justice of India, Chandrachud, said day before yesterday that trial magistrates are not giving bail, which is why each bench of the Supreme Court is saddled with 5 bail applications every day. 5 into 16, 80 bail applications every day in the Supreme Court. Why are magistrates not giving bail? And you have made it worse now by this provision. This is a completely retrograde provision. I'm absolutely certain it will be struck down as unconstitutional. But we must move towards that. What we are doing this is mobilizing legal opinion, lawyers' opinion, bar association's opinion. We are mobilizing political opinion. Every political party of the India bloc will be represented and they will speak for 10 minutes each. The idea is eventually we will have to gather and resolve to challenge specific provisions of these 3 acts in the Supreme Court. Challenges have been mounted in individual high courts to individual sections, but eventually all of them have to be consolidated and these laws have to be challenged. Simultaneously, we must mobilize public opinion against these laws. When these laws are implemented, all hell will break loose. You take it from me, when these laws are implemented, as Vivek said, all hell will break loose. Nobody knows the law, the police don't know the law, the lawyers have to relearn the law, and the judges have to relearn the law. And there will be utter chaos in this country. I condemn these 3 laws. I condemn the manner in which these 3 laws were passed in Parliament when there was no opposition at all. You suspended over 145 members and passed the laws with a one-sided debate. Our dissent note in the committee was not even considered or replied to by the Honorable Home Minister. We have written these detailed dissent notes. Every one of us, including me, have written a detailed dissent notes to each bill. No dissent was answered. This is a retrograde attempt to change the laws of this country, and I condemn it, and I ask you to express your views freely, not only in this forum, but in every forum that is available to you. Speak, write, talk to fellow lawyers, talk in bar associations, advocates associations. Let's mobilize legal opinion. Let's mobilize political opinion. Thank you.
Thank you, Mr. P. Chidamabaram, sir, for such an illuminated keynote address. Now, may I request Mr. Yashovardhan Azad, IPS, former Special Director, IB, to give us a different perspective and point of view on these 3 criminal laws. Mr. Yashovardhan Azad.
Mr. Chidamabaram, the chair, distinguished lawyers, distinguished MPs on the stage, ladies and gentlemen. Indeed, a great privilege to speak with Mr. Chidamabaram, who was my Home Minister when I was in the Intelligence Bureau. And normally, you know, the ministers are briefed by the bureaucrats and learn also from the bureaucrats. But in this case, the bureaucrats and the police officers are learning from Mr. Chidamabaram. So indeed, it's a great privilege to speak with you, sir. Thank you, AICC Legal Cell, Mr. Mittal, for inviting me, the only ex-police officer in this conclave. Thank you more because the committee which made the new laws were a couple of professors who did a part-time job with the help of a lawyer and another district judge. But no police officer was invited, and neither was he in the committee. And later on, when the parliamentary committee was also there and we kept giving our names, even the Indian Police Foundation was not invited. So apart from the MPs of the India bloc or earlier, who were not allowed to participate, and the bill was passed, there were also streams of various sections of society which never participated, and the bill came out. Let me say, from a policeman's perspective, I have a lot of issues with this act. And I've heard very intently what my Madhya Pradesh colleague, Mr. Tankha, has said, and distinguished Mr. Chidamabaram. From a police perspective, I find it absolutely amazing, number one, that the Indian Law Commission, which is there, was never even referred to for making this law. And this is one of the points which Mr. Chidamabaram has also been raising. Secondly, the amazing thing is that we are talking about decolonization. It is the latest buzzword, if you've been hearing, decolonization. And in this decolonized attempt, 95% of the laws remain the same. So that's a huge attempt. Third, the earlier CRPC at least talked about something modern in the 1880s. That is the police commissionerate system, which came in Madras Presidency, which came in Calcutta and in Bombay. In the new one, it's not there. So this is decolonization for you. And by the way, in the end, I would still appeal to the MPs that you are still going by the outdated colonial system of a collector, the Lat Sahab and the Kaptan in the district. Whereas you have the panchayat system, you have the electorate, but you don't have a Zilla Parishad which runs the district. Anyway, you know, the offshoot kind of bill making has resulted in another example you would have seen in Maharashtra PSA. And I'm sure, Mr. Tankha, you would have seen how this bill was done in the last session. And despite the Makoka, despite the UAPA, there is a Public Security Act in Maharashtra which is going to take care of the urban Nakshals. It's a joke. Second point, the FIR is a very easy thing, it's a very good thing. You made it, everyone can file FIR from everywhere. From Kerala, somebody will file an FIR about something and the preliminary can be done by the local police. But even I, as a policeman, I'm very scared of giving the powers of preliminary inquiry. It will create a huge, huge issue. And as it is, the enforcement officers, some of the dirty ones who are indulging in Makan Khali Karana and all these business, this is exactly the kind of business it will give rise to if you are given the power of preliminary inquiry. As a police officer, even I don't want, a remand for 15 days stretched across 90 periods. It's a huge responsibility. You know, there are two things a superintendent of police is very worried about. One is death in police custody. And we used to be horrified at the very idea of it. And second is a communal riot in your district. Because after that, when the Judge Sahab comes in a judicial commission, you've had it. I've suffered it, I know. The third point, a spate of definitions. So now in BNSS, I have a sub-inspector who can register terrorism. You have a UAPA Act where at least there are some safeguards. The DSP does is sanction comes from the government. But in this particular case, so I myself as a police officer would not like something like this kind of a ruling, which would allow my junior officers to run riot. Because everything you're not going to see except the grave crime reports which you're supposed to see. Nothing else has been done in the Police Act, by the way. That remains the same. That I'll come to later, how the systemic reforms are much, much more important than just changing laws. Secondly, we have the same problem in organized crime. You have a series of vague definitions. You have no definition for land grabbing, hawala, mass marketing frauds. So it gives a huge, huge scope for misuse. Come to petty crimes. There are a number of crimes which have been mentioned. And by the way, there is a phrase over there which says, any other similar acts. That's excellent. So it gives me a huge entitlement to just about register any kind of a case which I want to. And this is the reason why 66A IT was struck down by the Supreme Court for saying that it is just open-ended. A couple of other things, which is very, very important thing from the point of human rights. You know, there was this relaxation to the vulnerable sections of the society that they will be attended to for their statements and all that at their residences. There is no such relaxation now. There's another very serious one in 107 BNSS, and I'm scared as a police officer that while the investigation is on, your proceeds from the crime can be attached before the case is disposed of. Now, these are new things as I'm reading. I haven't still read through the whole act. There are a lot of missed opportunities, by the way. For example, when you're talking about video recording, etc., Mr. Raghavan, the ex-director CBI, said that the postmortems of the deaths in police custody and police encounters should have also been video recorded. And also, the drawing of the scene of crime on scale should have been admissible. There are so many things they would have got it if they would have asked a police officer. A simple suggestion would have enriched it. Now, I have another problem with the timelines. There were timelines even earlier. So there were earlier timelines too. So in these timelines, first of all, these timelines will go haywire. Now, who's going to monitor it? And if the timelines are not met, who will be responsible and what is going to be done about it? So this is something, when you throw things in the air without having the ability to control it, it's something wrong. You're doing a fraud with the public. Investigation. Now, I'll just conclude 2-3 more points, sir, given my time. Investigation for a police officer needs to be backed very strongly by two things. One is the prosecution. All over the world, you have prosecution-guided investigation. कहाँ पे वारंट है, कहाँ पे कहते हैं, किसको बुलाना है, किसको नहीं बुलाना है, किसके यहाँ सर्च कर सकते हैं, किसके यहाँ नहीं कर सकते हैं, should we get a warrant from the court? This an array of questions which need to be dealt with while the investigation goes. And second is the forensics. The support of forensics is extremely important, and now, if you're even watching simple things like Netflix, the kind of array of things which you have with the forensics can give you and strengthen your investigation is amazing. Now, what it says is that all this will be done in 5 years. What will be done in these 5 years? Is the center going to take care of under the modernization program? Mr. Chidamabaram knows it more than anyone else. So who will? The states are not spending enough money on the police or any kind of this kind of a modernization. So where will the money come from? And you have already made a rule stipulated that above 7 years, the forensics team has to go there. Now, let me remind you, there are about 813 districts? 730, okay, districts. Each of these districts would need at least 2 forensic, vehicles, the homemade labs, the manpower. And do you think it's going to come that soon? And even, I'm telling you, this will go on stretching beyond 10 years. Where will the stipulation which you have put down in law, what will happen to that if these are not adhered to? The other, a very important thing which I want to bring before the lawyers is, and it concerns you, is that, you can do a virtual kind of examination of the witness or the accused. Can you do it? I mean, when you are cross-examining somebody, you need that, you want to have that eye contact, you kind of see his, various actions. It's like the policeman, when he takes a statement, he knows half the issues. Now, these are issues which would have come to the fore if the lawyers would have been consulted, if the policemen would have been consulted, and that's why I think it's a ham-handed job. Now, in the end, let me say, even Justice Lodha, Mr. Bakshi, the great legal scholar, have said that systemic reforms are extremely important before changing laws. Changing law is easy, but institutional reform is difficult. The police, look at the police. I mean, today, in Odisha, they have gone back, a retrograde kind of order has been made, that the DGP under whom the power of transfer of DSPs was there has been taken and given to the home babus. The babus love ministers and ministers love babus, except some who know their ministry like Mr. Chidamabaram. So they rely on them so much. And now you can imagine if you have that kind of a posting, then you give that kind of a leverage and that kind of freedom to the police officers, then you know what will happen. Therefore, 3 things. This law is impractical. Number 2, it's fraught with legal implications. By the way, even the 10 or 15, and I think Mr. Chidamabaram also talked about it, important landmark Supreme Court judgments on these issues, whether it's on individual rights and other things, have not been incorporated in this. So, I would say there's still time to roll back the reforms. You must give it back to, and there should be a clutch of battery of lawyers, policemen, retired judges, ministers. Why should politicians be included? For the simple reason, it is the politicians who suffer the most by petty crimes being hoisted against them. And later on, they have to keep fighting, and it goes to the court that they have been there. Before coming, I told my brother MP that I'm going to address the criminal laws with Mr. Chidamabaram. He said, I'm very happy, please tell everyone, this is a bogus law, this is Modi's law, we don't agree with this law. So, thank you very much.
Thank you very much, Mr. Azad. Now, may I request quickly Ms. Sushmita Dev, Member Parliament, Trinamool Congress Party, to come and say a few words.
You want me to come quickly or to speak quickly?
I wish you to come and speak as at your at your leisure.
We are lawyers.
Thank you.
Every word.
Yeah. Thank you.
Thank you so much. I want to thank Mr. Mittal for organizing this. I'm absolutely honored to share the stage with Mr. Chidamabaram, from whom I have learned a lot, whether it's in Parliament or in courts. I'm very, very happy to see someone who I've looked up to all my life as a lawyer, Rebecca John. I'm very happy to see Senior Advocate Mohit Mathur. I remember going to his chambers when his father was alive and going very strong, Oh, he's still, okay. I'm sorry. But I remember that when he used to stand in court and defend, I happened to be in one of the matters, he had to say very less. That's the kind of credibility he has, that the judges respected him to that extent. We also have many honorable members of parliament here. I'm representing the Trinamool Congress, and please know that Chief Minister of Bengal wrote a letter to the Prime Minister of India on 21st June to say that under no circumstances should these criminal laws be implemented on 1st of July. But as is the new normal, most of these letters fall to deaf ears in this government. So she went on to pass a resolution in the assembly in West Bengal, where they decided that they are not going to accept these laws, the implementation of these laws. And she set up a committee of 7 members with retired judges and many well-known legal minds who are going to review it. And I think that's been done in many other states, including Tamil Nadu. I think after Mr. Chidamabaram has spoken, I don't need to go through every provision and how badly they have done it. And as a lawyer myself, I would like to say that we as lawyers never fear something that's new, because we're used to reading the new Supreme Court judgments, we're used to reading the new High Court judgments. But the point is that this copy-paste legislation, like Mr. Chidambaram said, we are having to relearn all the sections. Like Mr. Tankha and I were talking, 320 is no longer 320. So it's a humongous task in our already very busy legal practice. Very busy legal. We are a bit like doctors, you know. We have no timings. We work 18, 20 hours a day. And I think it's a huge burden on the judiciary too, to learn everything afresh and go through the things. And to top it all, I must say that the Home Ministry of India, the Government of India, had a similar conference like this in the state of Bengal, where lawyers were called and everybody was called to have a kind of interaction. And can you imagine that there was no involvement of the state government? And as in most cases, the Home Minister of the state is generally the Chief Minister in most of the states. So no information to them. They were just told we are having a conference in Bengal, and they went ahead with it. So these things tell us how this government functions. And be that as it may, apart from the fact that we have to put our minds together to make sure that this is not pushed through, I think what is equally important from a political perspective is to know that, as far as I remember, if a state is at variance with a central legislation, then it's the President of India who has to give their assent for a state to go ahead. So that's going to be a huge block for us there. I mean, given the way we've seen governors functioning. So I think because this is not it's not a regular conference where there are only lawyers. It is being hosted by a political party. So we will have to take up this issue on the ground, like the lawyers of Tamil Nadu very recently did at the Jantar Mantar. And we have to fight on the ground and build the pressure on the ground so that it reflects the mood of not just the legal fraternity, but of the nation in the way these laws have been imposed. And I just find it appalling. I just find it appalling the way it was pushed through, where 146 members of parliament were suspended and this was debated. And like Mr. Chidambaram was saying, and you were telling me about the police, nobody was allowed to come and speak in front of the standing committee. So if we have to reverse this, we have to reverse this together. and without focusing on what is wrong with the legal provisions, because you're all lawyers here, I assure you, from All India Trinamool Congress and Honorable Chief Minister Mamata Banerjee, who's also the chairperson of our party, that we stand in solidarity with all of you, and whatever it takes from here on to stall these laws, we will fight shoulder to shoulder with you. Thank you.
Thank you, Ms. Sushmita Dev ji. Now may I call upon Ms. Rebecca John ji, Senior Advocate, to come and give a speech. Thank you so much.
I think Mohit and I will tell you the confusion in courts at the moment. We are struggling with the savings clause of the BNSS, which is the new CRPC. There are one set of judges who believe that anything filed today will come under the BNSS, and there are another set of judges who believe that the older law would apply because there is a pending investigation or a pending appeal or a pending trial inquiry. And so even something as basic as the savings clause has resulted in a fair degree of debate in courts. Ultimately, it is the litigant who will suffer. I don't know how much of this has been covered. I'm sorry I came a little late. But for me, it's not so much the fact that there are new laws. I have no problems with change, and I think laws must evolve over a period of time. But what I find particularly disturbing is the introduction of special statutes within general penal law, including MACOCA, as well as various provisions of the UAPA. This kind of transferring offenses from special statutes into the general regime is extremely problematic. As it is, we are fighting the draconian natures of these special statutes, PMLA, MACOCA, as well as UAPA, and its indiscriminate use. And if this becomes part of general penal law, it will have a great, the backlash will be faced by citizens. What is also problematic is that some of the checks and balances which are there in the special statutes, including, for example, under UAPA, the checks and balances with respect to sanction, previous sanction, which is also a two-layered sanction. It is, of course, now followed in breach. But nonetheless, all of that is missing from the penal code. So while they have taken lock, stock, and barrel a lot of the offenses from these special statutes, they haven't really relied upon the parallel protections that citizens got. So the provisions of UAPA and PMLA, which and MACOCA, which have been introduced in the penal law, is extremely problematic. There have been amendments to speech offenses, including the reintroduction of sedition, which is actually a violation of the Supreme Court stay. And I noticed that the present 152 has increased the punishment. Earlier it was life, 3 years or fine. Now it's life, 7 years and fine. So the fine element, which was an alternative punishment, has completely gone from the sedition statute. Aside from this, there is also a amendment to what used to be 153B. It is now 197, which deals with imputations, assertions prejudicial to national integration, and it makes punishable anything which is made or published false or misleading information which jeopardizes the sovereignty, unity, integrity, or security of India. Now, this is couched in such overbroad language that the possibility of misuse is immense. There are provisions where, when you first read them, you thought that this was an improvement. For example, the new 436A, which is now 479 of the BNSS. One read it in the first instance, it was read to mean that anyone who has served 1/3 of the sentence is entitled to bail. However, once you read it more closely, you would find that there are many riders to it, including the fact that only first-time offenders were entitled to the benefit of this provision. And there's an additional clause which provides that an investigation, inquiry, or trial in which more than one offense or multiple cases are pending. So in every case, they are largely, I mean, I can't think of very many cases where there's just a single offense. There are always multiple offenses. So the benefit of 479, which is already undergone as an under trial, the period of custody will not be given. To my mind, the most complicated provision is 187 of the BNSS, which is the new, which was the old 167, which governs the entire spectrum of remand. Earlier, the first 15 days was police could be interchangeable custody, police custody, as well as judicial custody. That has increased under subsection 2 to the first 40 days or the first 60 days, depending upon the gravity of the offense. So there can be staggered police custody from day 1 to day 40, albeit only for a total of 15 days. However, the subsection 3 creates a confusion because of the deletion of the word otherwise than on police custody, and in some cases, analysts have said that actually police custody can extend for good reason up to 60 or 90 days because of the fact that the term otherwise than in police custody has been deleted. Now, I don't know whether this is conscious or this is just evidence of poor drafting. Either way, it will require some kind of judicial interpretation. Now, when countries around the world have done away with this concept, this archaic concept of police custody, to find that we have not only retained what existed earlier, but we have expanded the scope of police custody to a period of 40 or 60 days minimum, even if you were not to read subclause 3, although according to subsection 2, it cannot, the total period of police custody can't increase beyond 15 days, but the fact that you're staggering it between the first and the 40-day or the first and the 60th day actually is a matter of deep anxiety for any accused person. And the fact that you've allowed this is not reflective. It reflects poorly on democratic principles on which our republic is founded. There are preventive detention clauses, including 172, which permits the police officer to detain a person in police custody up to a period of 24 hours. As was earlier said, the BNSS also introduces many timelines, none of which will be followed, I can assure you. They will be followed in breach because these are very, very unrealistic timelines considering the pendency in our courts and the fact that we can barely conclude daily lists and give effective hearings to citizens. Aside from this, there are other provisions which are very, very problematic, including the introduction of preliminary inquiry prior to the registration of an FIR. I think once Lalita Kumari, the judgment of the Supreme Court, said that once a cognizable offense is made out, an FIR has to be registered. This power given to the police and it's an irrational power. It says that where the imprisonment is up to 3 years, you have to register an FIR. Where it is between 3 years and 7 years, you hold a preliminary inquiry. So the graver the offense, you hold a preliminary inquiry, and the less serious the offense, you register the FIR immediately. Likewise, there is provision for ex parte trials, something unheard of in criminal law for proclaimed offenders. And this is a very, very dangerous provision which will be weaponized in the years to come. There is another interesting provision, that is section 223 of the BNSS, where, again, this has turned criminal law on its head. When a private complaint is filed before a magistrate, the magistrate will first issue notice to the proposed accused and hear him, and then decide to proceed with the case. all of which, again, as I said, turns criminal law on the head. 377, a provision which was watered down by the Supreme Court when it came to consensual same-sex relationship, but was retained with respect to non-consensual same-sex relationship, has been completely deleted from the new IPC, which is the BNS. Also, there is, so therefore, adult cisgender men would have no remedy in law against sexual assault with the omission of 377. Section 69 of the BNS, which talks of a category of offenses that courts as well as practitioners were very uncomfortable with, promise to marry. It doesn't call it rape, it calls it sexual intercourse on account of deceit. Again, a section which will be weaponized when it comes to interfaith marriage, interfaith relationships, or relationships between different castes and different classes of people. Again, this is, I mean, on the one hand, you say women always make use of these provisions, and then you give them these provisions to exploit. These are some of the provisions which I find to be very problematic. I genuinely believe that the placement of sections, which has changed now, will cause a world of pain to lawyers, to judges, and to all those who access these laws. 302, which was murder for over a century, has now shifted to 101, and likewise every provision largely as was used has changed its position. Why that was done, I don't know, but if the idea was to introduce some new provisions, you could have introduced them towards the end and retained the placement of these sections. And I will not be exaggerating when I say that the new placement of sections is in fact something which citizens will find very difficult to grapple with. This really is my, I wanted to keep it brief, but these are the provisions which I believe which are problematic and which needs urgent reconsideration. Thank you.
The party to give his address. Mr. Malwinder Singh Kang, Member Parliament.
मेरे लिए बड़ा ऑनर की बात है, हम शेयरिंग द स्टेज विद ऑनरेबल पी चिदम्बरम जी। इनको तो हम छोटे बच्चे थे तब से सर हम आपको सुनते भी हैं और समझने की भी कोशिश करते हैं। सो बेसिकली कानून तो बनाए जाते हैं लोगों को हिम्मत देने के लिए, ताकत देने के लिए, सुरक्षा देने के लिए, मेरा तो ये मानना है। बट जैसा चिदम्बरम जी ने कहा, दीज लॉ इज क्रिएटिंग मोर कंफ्यूजन, नॉट ओनली कंफ्यूजन सर, इस स्ट्रेंथन द पुलिस एम्पावरमेंट। जिस तरीके से प्रेजेंट गवर्नमेंट ने ये नए कानून लाए हैं, उसमें तो ऐसा लगता है कि दे वांट टू मेक ए पुलिस स्टेट, not a democratic state, or we already faced what is a police state. पंजाब में वेरी नोन एक ह्यूमन राइट्स एक्टिविस्ट हुए हैं जसवंत सिंह खालड़ा जी। उन्होंने he identified 25,000 unidentified dead bodies, और एक दिन ऐसा आया कि उनकी भी जो बॉडी, डेड बॉडी जो बोली, वो भी अनआइडेंटिफाइड थी बिकॉज ऑफ इट्स अ पुलिस स्टेट। पुलिस तो एक दो दिन में भी उसकी रास्ते में एक आम आदमी रह जाए तो उसको तो मुश्किल हो जाता, सारा कुछ कहलवा लेते हो। तो यहां तो आप कह रहे हो कि उसकी कस्टडी, एफआईआर ही 14 दिन तक नहीं। एफआईआर के लिए तो हम लोग कोर्ट्स में जा रहे हैं आज तक, ज्यादातर तो यही हो रहा है सर। एफआईआर के लिए एक आम सिटीजन को, साधारण नागरिक को कोर्ट में जाना पड़ता है, मेजॉरिटी ऑफ देख रहे हैं हम केसेस में। और यहां 14 दिन का उनको फ्लेक्सिबिलिटी दे दी है पुलिस को। और कस्टडी की बात हुई है, यहाँ से पहले 15 दिन थी, 15 दिन 60 to 90 डेज, 90 दिन में तो वो अक्यूज्ड को कन्विक्ट भी करवा सकती है पुलिस, इस तरीके से बिहेव करती है। तो मुझे लगता है भारत सरकार की जो ये नए तीनों कानून हैं, CRPC, IPC एंड इंडियन एविडेंस एक्ट, ये उनकी जो मेजॉरिटी का अहंकार है उसको ही दर्शाते हैं। अभी विवेक तनखा जी ने जिक्र किया था किसान आंदोलन का, तो इसमें तो ऐसा लग रहा है भी जो किसान आंदोलन की कारगुजारी रही है, बेसिकली एग्रीकल्चर स्टेट सब्जेक्ट है, चिदम्बरम जी तो ज्यादा अच्छे से समझा सकते हैं हम लोगों को, और मुझे नहीं लगता उनके की नोट एड्रेस के बाद मेरा बहुत कुछ बोलना बनता भी है। लेकिन जिस तरीके से फोकस किया है कि एक डेमोक्रेटिक एजिटेशन को भी सिटीजन्स के चार्जेस लग जाएंगे कई और राजस्थान में अभी हुआ है रिसेंटली, सबसे पहले वहां तेजेंद्र सिंह पे केस ऐसे दर्ज हुआ है। तो डेफिनेटली आम आदमी पार्टी इन तीनों कानूनों को लेकर डेफिनेटली अपना ऐतराज दर्ज जताती है, इसमें कोई दो राय नहीं है। और हम इंडिया ब्लॉक का भी हिस्सा हैं और देश के लोगों ने भी अभी जो मैंडेट दिया वो डेमोक्रेटिक तरीके से अहंकारी डिक्टेटर सरकार को एक मैसेज दिया है। थैंक यू वेरी मच मित्तल साहब।
Huda, Senior Advocate, Supreme Court, Convener, Supreme Court Legal Cell, to give his address. Mr. Narendra Huda.
P. Chidamabaram Saab, Member Parliament and former Home Minister, former Finance Minister, K.C. Mittal Saab, Kang Saab, Member Parliament, Mohit Mathur ji, President, Delhi High Court Bar Association, Sanjay Bansal ji, our Secretary, K.C. Mittal Saab, Sanjeev Nasir, our bar leader, sitting here. Thank you very much for inviting me here. Of course, it's a pleasure and honor to share dais with the legal luminary and a statesman like Mr. Chidambaram. It's a very good initiative Mittal Saab has taken to invite us all to share our thoughts on these new criminal laws. Chidambaram Saab and Tankha Saab both have at the outset emphasized one fact, that 90 to 95% is the same cut and paste. I wonder, if it is same cut and paste, then why repeal all the three laws which were in existence for decades, bring new law with changed sections? What is the intention behind it? The answer that comes to my mind is, this government which claim a brute majority has an overconfidence of repealing the settled law, bringing in new law without even referring it to the Law Commission, which is a statute which is meant for this purpose. The motive and desire emanate from creating a narrative that we are for the first time doing Indianization of these laws. I find that this narrative is not going to sell, because this project of Indianization of Indian laws starts and ends at the cover page of these laws. Merely because you call them with Hindi names is not Indianization of the laws, in my humble view. So I would call it as a political misadventure which the courts, the litigants, and the citizen of this country will suffer I don't know for how long. There are numerous provisions my learned colleagues have talked about. Ms. Rebecca John has talked about section 223 of the new Suraksha Sanhita, which talks of giving notice to the accused before the court takes cognizance. It is clearly contrary to the criminal law. This amounts to a trial before the trial. If the trial begins after framing of charge, or in a complaint case at least when the accused is summoned, the cognizance is taken. Here, before cognizance is taken, the court magistrate will issue a notice to the accused that what you have to say, and then the accused will deploy his own dilatory tactics to delay first the summoning and thereafter the trial. In the same manner, there is a provision now introduced for the first time of a preliminary inquiry before registration of FIR. It was with decadal experience that in Lalita Kumari Constitution Bench of Supreme Court said that as soon as the complaint discloses commission of a cognizable offense, you register an FIR and then investigate. This conclusion was arrived at after decades of experience of the citizenry who had interface with the policeman in the police station. Now all has been done away with. Now first 14 days is given to the investigating officer who in the first stage receives the complaint. He doesn't do it, then he goes to the SP. There's no timeline given to the SP how much time he will take to reach a conclusion to register an FIR or not to register an FIR. So, whether it is a case, it's a complaint case or an FIR case, the agony of the complainant has been enhanced. I remember the Home Minister of India, while introducing these 3 new laws in the Parliament, it said that now the emphasis is on justice instead of punishment. When they replaced the word Nyay Sanhita instead of penal code, again I would say this sentiment of theirs starts and ends at the cover page of the book. There is no nyaya for the complainant, there is no nyaya for the accused. Complainant's agony has been enhanced. Draconian provisions like solitary confinements have been introduced. There is another important aspect which Ms. Rebecca John had briefly touched. Now there is overlapping of special acts with the general acts. Under the Maharashtra control of organized crime and Gujarat control of organized crime and UAPA, there is a organized crime and terrorist act are defined in those acts. There is a reverse burden of proof on the accused under those acts. Now, those offenses have been imported here in the Dand Sanhita now this new act. And those penal acts are still there. Now, when a complaint comes to the police station, the SHO is now free to decide whether to invoke Makoka, where reverse burden of proof is there, or to invoke IPC. If he is more benevolent, I do not know ultimately whether IPC will be beneficial to him or Makoka or Gujarat Control of Crime Act or UAPA will be more beneficial to him. But this unguided discretion has been given to the police officer to rope in the accused, whether under the new act or under the special act. It is not for the first time that the laws are being rewritten. CRPC was substantially rewritten in 1973. The government of the day wanted to usher in reforms. The process for analyzing the amendment started in 1961. There were numerous law commission's reports starting from 32nd report, 33, 35, 36. Then came a 41 report containing comprehensive consolidated recommendations. Because the government of the day intended to bring in reforms, it was not in a hurry to fulfill their some impulse to create some political narrative. Here was a case where the government in a hurry constituted some academic committee which had certain professors, only one lawyer who actually practices law. This was, in my humble view, no way to amend such settled laws. It takes years and years to settle law in courts. Every provision is interpreted over a period of time. It comes to High Court full benches, Supreme Court Constitution benches, then a law is settled. And after the law is settled, the trials can proceed faster. Now, in the garb of, though it is 95% same, but again, it's a lawyer's paradise. Nobody can prevent an accused arguing that that settled law pertained to so-and-so provision and there is a little tweaking of the provision and he will start arguing completely afresh. And the trial court and the high court will again sit to decide and decipher whether the law earlier settled will apply or not. So it will further delay the trials. It is not enhancing the cause of justice. The courts are already clogged with backlog. Every day we talk about the backlog. Now these new laws are in no way advancing that cause. The government talks of more forensic evidence. We are already forensic evidence based trial we conduct in this country. But where is the infrastructure? One report from the forensic laboratory takes 6 months to 1 year. And this is how the trials wait to conclude. Now you are generating, of course, more work for those laboratories, but where is the budget for enhancing the number of laboratories? So it is all theory. In practice, because there was no wide-breast consultation with the legal fraternity, and in a hurry they brought these laws. And at last I would say, these laws had come in a common parlance. Every layman could associate with himself or herself with the laws and had little confidence that I know what 420 is, I know what 302 is. In villages, illiterate people can say कि जी 751 हो जाएगी. Somebody say वो बहुत 420 किस्म का आदमी है. These new laws has taken away my language also in part. In common parlance, it is not giving us, it's very difficult to now acclimatize ourselves के वो 318 किस्म का आदमी है. So now at what cost? This really baffles me. And I'm pained and saddened to notice that it was all a political misadventure this government had, and for how long we will suffer for it. Thank you so much.
Thank you very much. Now, may I request Mr. Mohit Mathur, President, Delhi High Court Bar Association, to present his papers.
Honorable Mr. Chidamabaram and the other dignitaries on the dais, off the dais, my dear friends, first I must express my gratitude to Mr. Mittal and his team for having thought of inviting me. With all the illustrious people having spoken before me, I am feeling like Rohit Sharma's team having batted, and as the last tail ender, with whatever balls are left to spare, I must start hitting whether I cross the boundary or not. But I in fact feel the same way as Rebecca said, and both of us have had the occasion of speaking on this subject for the last about 2-3 months. As lawyers, we don't have any problem in introduction of law. We are trained to interpret, we are trained to implement, execute, apply it to the cases at hand. No issues. Please do so. Make as many laws as you want. Only it will add to the briefs that we have. But there are certain things, as rightly spoken by Mr. Huda, कि अब 318, 101 ये सब याद करने बहुत मुश्किल है. And not just us, even those sitting on the bench are finding it difficult to come in grips with the new provisions. And Rebecca rightly pointed out, in fact, Delhi High Court right now is finding it very tough to deal with what provision to apply, whether 482 of the CRPC will apply or 528 of BNSS will apply. Because 482 of BNSS today becomes the anticipatory bail. Similarly, what Rebecca said was that high courts all across the country and the courts, in fact, are finding difficulty interpreting the savings and repeal clause. I somehow have difficulty in the preamble itself. The preamble to these two, the Bhartiya Nyay Sanhita and Bhartiya Nagrik Suraksha Sanhita, start with the word, these are acts to consolidate and amend the laws. Somehow, I don't know, what we learned in the law schools was consolidation means whatever is existing is being consolidated at one place and the others have to be given a go-by. But unfortunately, the provisions of the special laws which have been included in this still leave room for a police officer of Superintendent of Police to decide whether he will opt for UAPA or he will opt for the BNS. This kind of a latitude given to the police may create some problem. In fact, I was pleasantly surprised with Mr. Azad saying that the police agencies were not consulted. So if the police agencies were not consulted, I really don't know who were the stakeholders who were consulted. As far as I am concerned, as a counsel, I find difficulty in the gaping holes that are left. When you introduce a section or you incorporate a section from somewhere else, या तो आपने उस सारा का सारा लिया होता बट आपने सिर्फ वहाँ का penal provision उठा लिया और डाल दिया into organized crime or into terrorist act and other places. Without, and as rightly pointed out by Rebecca, the safeguards are missing. The provision for sanctions, the prior sanctions are missing. And the unfortunate part is, though it sounds very nice to say that the bail provisions become easy under the BNSS, but the safeguards under the special laws are also to safeguard at the time of investigation, which becomes today dangerous, because a sub-inspector of police can start. Maybe in the commissionerates we have higher ranking police officers to take care, but in the other hinterland we'll have that problem. A major area of concern as a council, I feel, is in the provision of registering an FIR. The introduction of the word irrespective of the place where the offense is committed in 173 makes an offense committed in Rajasthan to be investigated in Assam. Because irrespective of the place where the offense is committed, this FIR can be registered. Though the concept of zero FIR was understood by the Supreme Court in different judgments and said that you will shift it to the place where actually the offense is to be tried. Because of the sections which deal with the provisions for where the trial is to take place are remaining the same. What used to be 177 onwards is 197 onwards. But adding this line, irrespective of the place where the offense is committed, to what used to be 154 is now 173, creates the havoc. Now, doesn't end it at that place. It says, if you find a prima facie case, you can continue to investigate. Now, investigation includes arrest. So a judge who is not capable under the law, who is not competent to try you, will deal with your remand and bail applications. And just doesn't end there. Investigation includes the provision, as Mr. Kang also pointed, or Mr. Azad also pointed out, attachment. So now that attachment under 107, which is generally under the special laws, is introduced in this general law. Now the attachment of your assets to be declared as proceeds of crime without the trial having started, because there is a parallel provision of evidence to be recorded here. Now a judge on an application can attach your assets also, sitting in Assam, dealing with Rajasthan. So across the length and breadth of the country, anywhere, anything can happen. Now, as a council, what I need is some kind of an SOP, some protocols defined. We have spoken about it at several forums. We have spoken and written as stakeholders. I hope somebody wakes up. Because this, we are not making a temporary or a transitional provision. This is going to be the law which is going to run the entire criminal justice system. Trial in absentia, briefly, Rebecca said, but when a trial is in absentia is to be done, I did not even know if an FIR is registered outside. And it gets transferred with the collection of whatever little evidence to the place of competent jurisdiction. I don't get to know about it. I am declared a proclaimed offender and trial in absentia takes place. Earlier, trial in absentia ended till the time evidence was collected and evidence was recorded. Judgment to be pronounced was not included. Now a judgment can be pronounced in absentia So all my safeguards go away. All my liberty principles are thrown to the winds, which I hope either the courts or the executive comes to our rescue, because as lawyers we'll continue to only cry hoarse if only somebody listens. My learned friends who have spoken before me have also taken you through different things and different provisions, and as counsels I feel all of you will be going through. But certain very interesting aspects have been added which somehow makes us uneasy. One of them is section 172 of BNS. A person can be arrested for refusing to comply with the direction of the police. It's an offense. He can be released if the judge feels when he's produced it's petty. But what is going to happen to him? Who's going to decide what was that refusal about? He's resisting. He's refusing. Now these are words which are allowing the person, the law enforcement agencies, to play with the liberty of an individual, which as a lawyer who has primarily practiced as a defense counsel makes us very uneasy. Sodomy and bestiality today has been taken away under 377, having been removed, and there's no parallel to it. Only leaves an adult male vulnerable, especially as inmates of prisons and other shelter homes. There is no parallel or equal to it. Probably only hurt or grievous hurt would be the only provisions where he can prosecute. And lastly, something which is on the recording of evidence is something I feel is serious, that you are making all these electronic evidences as primary evidence, which makes it very difficult, because with this today AI and other tools available, deep fake, etc. So AI today is only growing. We just had a demonstration of recording of evidence by verbally, and it gets translated and transcribed immediately. It happened at the Hazari courts just as a model and experimental basis. It even took into account the accents, and one of the honorable judges tried his accent of Haryanvi, and it came out very nice. So if AI can start controlling things and allowing that kind of evidence to become primary evidence, it's something a little dangerous. One part which also will require people's consideration, and each one, whenever gets the chance to challenge it, will have to see, is all search seizure provisions have to be videographed. And in fact, at one of these forums, a police officer very interestingly told a tale that on 3rd or 4th of July, one of the sub-inspectors was on his duty on the patrol, and somebody told him that in the park just inside he found some blood-soaked clothes. He went inside and he was told by his constable that it has to be videographed, but there was no light there. So he took it out of the park, and where there was the lamp post, he kept it there and started videographing. Now these are the kind of situations. He's already changed the situs because he had to videograph. Now videography, there's a tool which is the app which the police agencies are creating. In Delhi, they have created it by the name of AICC. Again leaves it to the police officer, because he will videograph it but he has to within 2 days upload it. That will give him a certificate under 63, the new 65B. But it doesn't take into account what we used to, as Defense Counsel, always rely on. What is unrelied document also seized by you? Because that will get lost under AICC or any such app. Because if he doesn't present it, it gets destroyed automatically because his phone is not going to be a part of the 65B and 63 now. And 63 certificates, if anyone has seen the Form A and Form B, God only knows who's going to fill it. Hash values, IMEI numbers, etc. Only an expert will have to come down and do it. At least none of us. So I'm sure as it goes on, both the challenges will continue as well as we will struggle it and battle it out in the courts. So leave it to what happens. Thank you very much.
Thank you, Ms. Mohit Mathur. Now, may I request the last speaker of the evening, Dr. Fauzia Khan, Member Parliament, to come and give her address. Dr. Fauzia Khan.
Honorable Dais and everybody present. Here I am representing NCP Sharad Pawar Party, and I would like to express my thoughts. So this, first of all, I think it's a very welcome step that such a conclave is taking place, because all of us are kind of bewildered. In the way that civilizations and societies evolve, nations evolve, laws are also expected to evolve and become more relevant to the changes. In earlier days, the laws were jiski lathi uski bhais. In later days, laws were designed for the more powerful. Today we live in a democracy where laws should be inclined towards the weak and the oppressed and simultaneously be in tune with the Constitution and its core values of freedom, liberty, equality, and so on. Charles Darwin, who's called the father of science, has said that it is not the strongest of species, strongest and the most intellectual of species that survives, but that which adapts itself to change. I am happy that our government has at least thought that adapting to change is necessary. While dealing with issues related to our criminal jurisprudence, we on the one hand must ensure that we deviate from the oppressive laws of the colonial legacy, and on the other hand, we have to remain firmly rooted to our constitutional values. This balance is what is crucial. And it is not just the laws, but it is the entire judicial system that has to adapt itself today to this balance. What is good about these three criminal laws is there is an effort to integrate technology into the system, which he was speaking about it. The use of technology has a good side as well as a challenging side. So it's a double-edged sword. I agree with it. For instance, as he said, the use of artificial intelligence and other rapidly evolving technologies can be used to alter electronic evidence. So a layperson like me also understands that. Not that electronic evidence, I hope, but what I heard from him is that it is going to be considered as primary evidence, and that is a matter of great deliberation, I feel. We need to deliberate on that. Another thing that is good is an effort towards gender justice, because these laws speak about, but more stricter laws, more stringent laws have to come towards crime against women and children. And even here, I feel more deliberation was needed, But the absence of deliberation has created a kind of confusion, and that is why we are here. Bhartiya Nyay Sanhita, Bhartiya Sakshya Adhiniyam, Bhartiya Nagrik Suraksha Sanhita. I don't know, it's so difficult even to pronounce these names. And the South Indians are really, aghast about it, that we cannot even pronounce, so how can we do it? And they feel it's a big injustice. So what I feel is that 90 to 95% of the same old laws that were followed in the CRPC, IPC and the Indian Evidence Act, apart from a few instances, have been changed. It is just, the same old laws wearing new clothes. We are, in fact, more draconian than our colonial past and compromising on our freedom and liberty. That's very strict. The only way...
Thanks, and invite all of you for tea and all the snacks. Thank you, sir.
We have a young Lok Sabha member from Karnataka here, Mr. Sagar Eswar Khandare. We welcome you, my friend. I really touched with today's program, and I have no words to express my gratitude to Mr. P. Chidamabaram, but for his step-by-step, morning, night, emails, guidance, that we have reached this stage and this program is a success, and because of the presence of all of you. We are thankful to you, sir, and it was really for the first time I have been so successful and so happily conducted this program with your guidance, sir. I am thankful to Vivek ji, Vivek Tankha ji, Sushmita Dev ji, Malwinder Singh, Kang ji, and the way Mr. Yashovardhan Azad, as a former Special Director IB, explained, Rebecca, Mohit, they were so excellent, they could explain how and what are the basically the amendments in the three laws, how they are the draconian. And I've been saying it as if we are heading for a police state. This is what the law is. It's basically an arm twisting kind of, nothing more than that. You're giving unregulated and unbridled powers to the police, which at least in India it can't happen. I'm so thankful to Mr. Narendra Huda, our friend, and all of you, particularly my teammate. I can see the smiling Sanjeev Nasir, the chair of the AAP Party Legal Department. Thank you very much for helping us. Pradyuman Singh, he is a 24 hours, 24/7 hard working with us, and he is the one who is controlling. Deepak, Tyagi ji, and my friend Harish Bhatia, of course, batchmate, Rekha Khanna ji. Most of you, those are present here, I'm indeed so delighted to find you that after a long time, the AICC Legal Department could hold such a successful program because of you. The whole credit goes to you, all the friends, and I tell you, you have set things to motion. that as far as these laws are concerned, the entire legal community, not only in Delhi, we had requested, I think Mr. Devendra Yadav has struck up some band, because we want Delhi lawyers, if they take the lead, we've been doing it even in the Bar Council. And I must mention one interesting fact. Atul is here. Atul Sharma is the Secretary of Tisajari District Court, and he is also the Secretary of the Coordination Committee. I had requested the chairman also to be here, but maybe, and they did it. What did they do? One day there was a strike in Delhi on these laws, and you know the result? They achieved something. And what did they achieve? Their achievement was the video recording of evidence from the police stations. That the Home Secretary issued a notification there and then on when they protested, and they had a long meeting with him, with the committee. And I think I must thank the Coordination Committee for taking this initiative. Thanks to all of you, friends, and if anything has missed, if I missed, Tyagiji muskura raha hai. So please excuse me, and I'll invite all of you for a cup of tea and have good photographs with Mr. Chidambaram and all the guests. Thank you very much.